Welcome back. The E. Jean Carroll versus Donald Trump case wrapping up this week. The jury finding the former president liable of sexual battery and defamation, awarding Carroll, who accused Trump of raping her in a luxury department store back in the 90s, $5 million. Trump and his lawyers have appealed that verdict. That happened on Thursday. Reaction now coming in from both sides. Newsmax's John Glasgow has that part of the story.
Political reaction rolling in this week. Republicans seem split on the verdict, some siding with the former president, suggesting that this case is politically motivated.
Yeah, I think the New York legal system's off the rails when it comes to Donald Trump.
What's happening in some of these courtrooms in Manhattan, I don't even know. I'm not going to get into it.
It's a jury of his peers finding him.
Come on, man, serious? Don't say that stuff to me. That might work for somebody else. That definitely don't work for me. The jury of my peers, yeah, whatever. What else you got?
I mean, that's pretty much it. This is a sexual abuse conviction, basically.
It's an allegation from, what, 25 years ago?
Trump's GOP rivals staying quiet. No comment from Tim Scott, Nikki Haley, or Ron DeSantis, but others, including Senator Mitt Romney and presidential candidate Asa Hutchinson, had this to say.
I think it will bother many in the base, but it also depends on what people say about it and how they approach it. And for example,
what does that mean, what they say about it and how they approach it?
Donald Trump is going to say this is old, these are false, it's a crooked system, or it's a fixed system. Well, some will buy into that, but I think whenever you have leaders like myself that speak out, Senator Cornyn, it does make a difference.
A day after the jury's decision in the civil case, E. Jean Carroll spoke on the verdict in what seemed to be a victory lap.
Every single witness, every one of those 11 witnesses who testified in this case, testified under oath and told the truth, not because they don't like Trump, but because it was the truth. That's what this case was about. Who was telling the truth? The jury decided that E. Jean was telling the truth. And there may be witnesses who don't like Trump. There may have been jurors, as Joe Tacopina said in his opening, who don't like Trump. But that process was about the truth under the law, and that's what the jury found.
And this week, CNN hosted Trump for a town hall in New Hampshire. The former president was asked why he didn't testify at the trial.
This was a rigged deal. My lawyer said, sir, you don't have to do it. I actually said, I think I should. It would be respectful. They said, sir, don't do it. This is a fake story, and you don't want to give it credibility. That's why I didn't go.
One thing you did do in this.
And I swear, and I've never done that, and I swear to, I have no idea who the hell, she's a whack job.
Trump's legal team is working on an appeal in which they think they will win. The question is, how will this hurt his political aspirations? For Newsmax, I'm John Glasgow.
All right, thanks to John Glasgow for that report. Let's continue the discussion with our legal panel. We have constitutional law attorney and former prosecutor Amir Benno and distinguished professor at Touro University, Thane Rosenbaum, and our special guest, former federal prosecutor Katie Cherkosky. Amir, Thane, Katie, great to have you guys here. Amir, I want to kick it off with you. Talk to us a little bit about how you saw this case unfold and whether you were surprised by the outcome.
Well, I was not surprised by the outcome. I mean, I do think this is very slanted. Obviously, the venue is, stacked with jurors who despise Donald Trump. So from the jump, this was against him. And so I don't think him showing up in court would have swayed anything, frankly. And I think a lot of the judges' rulings went against him. So I think there's a lot of appealable issues, whether or not this statute that allows you to look back 30, 40 years and bring a civil case against somebody, that long ago is constitutional, whether or not basing the case on what they call propensity evidence. That means other acts and other instances with other people saying you did bad things allegedly to other people, so therefore you must have done this. That was essentially the plaintiff's case here, whether that was okay. And keeping the jury anonymous. That really handicapped the defense from being able to do the research necessary to make sure there was a jury of his peers. So there's a lot of appellate issues here. I'm not surprised at the outcome, but the fight goes on.
Katie and I were just watching that clip in John Glasgow's report of former President Trump when he was saying that he said he was willing to testify, but he was told not to testify because it was a fake news story. Katie, you mentioned to me that you thought that might have made a difference, which would kind of go against Amir's analysis that it could have impacted the case.
Well, I defend a lot of sex crimes cases. I used to prosecute them as well. And I think when we're talking here, this is not a criminal case, it's a civil case. The burden of proof is only a preponderance of the evidence. And Amir's right, there was a lot of rulings that were very against Donald Trump's side. There was evidence that was let in about other victims. There was the Access Hollywood tapes. There was obviously his deposition where he doubled down on some of the comments about groping women in the past. And so I do think that when you have allegations like that and a very low standard of proof, that he needed to get up there, look them in the eye, and say he didn't do it. Because otherwise, they have all of these other people saying they had something similar happen. They have all the evidence that was allowed to come in on that front. And then she's making these claims that are, in a criminal court, would have never been proven. But because of that standard here, could have made a difference.
Thane, give us your take.
Look, I agree with both of them, and Amir is right. Amir and I have been saying, I've always thought this, remember, this is a Me Too Believe Survivor statute. It's very important for everyone to remember that Donald Trump was required to defend himself in a defamation case that was based on a criminal rape charge that was never brought, that there was no police report, there was no rape kit, that was beyond the statute of limitations, because New York State passed what I think is fundamentally a problematic constitutional law that said it doesn't matter when it took place. It doesn't remember, you don't even have to give us the date. If you think that you've been the victim of sexual assault, you have a 1-year window to bring it, and just bring it along anyway. And I think that that's something we're not talking about. We're talking about this as if it's a rape case, but you don't bring rape cases in civil court. You don't bring rape cases 30 years after they took place. And you don't, as both we've all said, you know, the evidence that was presented here is presented that would have never been brought in a rape case. And today, no prosecutor would have brought under these facts the rape case. So again, fundamentally, there's a constitutional question of whether the statute that allowed Miss Carroll to bring a rape case disguised as a defamation case, right? There are no charges here. He simply said, I didn't rape you. And then lastly, when we heard Roberta Kaplan say the jury said that she was telling the truth, no, they didn't. They said the exact opposite. They said, you weren't raped. You were subjected to a sexual assault, but the allegation is rape. She was bringing a rape charge, and the jury ultimately concluded she was not credible on the charge of rape. So I've said on Newsmax before, I don't see how you get defamation unless you can prove rape. And the jury said that she only got as far as proving a battery, sexual in nature, but not rape.
We have about 1 minute left. Amir, what happens next? What happens with the appeal?
He's going to litigate it, and I don't know whether he'll have any success in the Second Circuit. What I will say is if he did take the stand, just getting back to that, he would have opened himself up to cross-examination, impeachment, any bad act, any alleged bad thing that he had done, any lie that they said that he had said ever, he would be cross-examined. That would go on for days and days and days. He would have gained nothing from taking the stand. He was better to take what they call the adverse inference from not showing up. But right now, he's got some real meat and potatoes on this appeal, and hopefully the judges on the Second Circuit will be impartial and unbiased and address it the way they should without any particular proclivity one way or the other.
Amir Benno, Thane Rosenbaum, Katie Cherkosky, appreciate you all being here. Thank you so much.
Thank you.